Carol, before I ask you about the GMC, I was asking you about the meeting you'd had with Anne Milton, and there was that reference to a vital document. And your legal representatives have suggested to me that it might have been the 1978 Dr. Preston article. Does that prompt a memory? Is that the case?
It might have been that, or it might have been Preston's. Could have been his what he compiled for Pete, possibly. Yeah. The litigation, maybe.
And then just one other point of detail. I asked you about the New Zealand family, and again, we're not mentioning any names. Is it your understanding that that family or the child later got a payment from the Macfarlane Trust?
Yes, because I actually made a phone call at one point to discuss with Anne Hithersay to make sure that they were registered.
Okay, which would reflect then an acceptance that the infection was in the United Kingdom?
Yes, yes, they are registered.
So if we just then turn to the GMC investigation, I'm going to take the points I want to explore with you from your statement. So it's WITN 1055004. And I think it's page 208, yes. So you detail in this section of your statement the complaint that was made by you and by Pete to the GMC in 2003. And there were a number of issues, but probably at the heart of it was the testing for hepatitis C without permission and the not informing Pete of the result until 1994.
Absolutely, and also realising that it wasn't only Pete, at that centre and across the country.
Now, we're not going to go to the underlying documents, because what I wanted to explore with you is your experience of the GMC's decision-making process, and the observations you make in your statement about what you perceive to be deficiencies in that process.
Right, okay.
Rather than the substance of what, whether what Dr. Jones said was right or
yes,
wrong.
Yes.
If we just look at the bottom of that page, paragraph 891, you say this: as the complaint progressed, it became apparent that Dr. Jones was privy to all our allegations, but his responses to them were not disclosed to us throughout the course of the complaint. I feel that this was procedurally unfair, as it gave Pete and I no opportunity to challenge any information which Dr. Jones gave in his response. We were totally in the dark.
Yes,
so
exactly.
Is this right? You filed the complaint and the information in support of the complaint. That's then shared by the GMC with the doctor.
Yes.
Now, that's understandable. I imagine
Absolutely.
you would agree, as a matter of fairness, if someone's being investigated, they need to know the information and the allegations against them. Your concern is that when a doctor, and it doesn't really matter for these purposes, it matters to you, I know, sorry, I shouldn't put it that way, Carol, that it was Dr. Jones is very important, but in terms of the process, whoever the doctor is, your concern is that whatever they say to the GMC is then not fully shared with the complainant, or not adequately shared with the complainant, so that you can't then say, well, actually, no, that's wrong, or I've got something that proves
yes,
that's
because
not correct.
The way we looked at it, they could have been saying absolutely anything, but because we couldn't respond or challenge, then we felt like we were arguing in the dark.
On top of the next page, you say, I'd not seen the full response until far more recently. Was that when it was provided to you by the inquiry, or had you obtained it before then?
I think within the last 2 years, I'd made another application since the inquiry was announced, and I got to see more documents. And I thought, if only I'd seen these at the time, I could have responded.
And you say that if we'd been afforded the opportunity to respond, I think we would have been much more likely to succeed in our complaint. The process as it stood allowed inaccurate information to be peddled by clinicians without the knowledge of their patient complainants.
I mean, if I could just give one example.
Yes, of course.
I since found out that a certain very well-known haemophilia, well, I'll name him, had written a support letter in support of Dr. Jones saying, I know this this gentleman, and basically I couldn't imagine that he would do the things that are being alleged. And I thought, well, how does he know? He's never seen, he's never witnessed a session between Pete and myself and Dr. Jones. So he's only making a very general statement. Because he'll know him from conferences, and I'm sure, but I thought that was completely unfair that was used against us. And then also, Dr. Jones had got a support letter from a haematologist, I think it was in the US, quite a well-known person, and I thought, well, what would that person in America know about Dr. Jones' day-to-day interactions with his patients on hepatitis C testing or not on hepatitis C testing. So the examples that we used against us were quite vague.
And then you go on to talk about what was being said in response to your complaint, and essentially what was being said was the opposite of what you were saying was the factual position.
I mean, I would say this. When we went away, we're the kind of people that do things properly. And as mentioned before, we had been very careful with our insurance. We'd paid a lot extra to get special insurance for HIV, for haemophilia, for my asthma. Everything was laid out. If we had known, why would we not have hepatitis C there?
And without going through the detail of it, if we go over the page, you've set out a number of points. I don't need to go through them. The point here you're making is that these are some of the points you would potentially have wanted to make to the GMC if you'd had the opportunity as part of the process.
Yes.
And then if we go to the bottom of the next page, you said at paragraph 898, I do not know whether there has been any change in procedure, but if not, I hope this is an area in which the inquiry considers making recommendations which suggest that the GMC move towards a fairer, more equitable system, which puts patients and clinicians on a more equal footing when complaints are made.
And I actually have seen more recently the GMC submission to the inquiry where I was mentioned by name. And I think they must have taken on board some of what I was saying, because there was something, I think, in that document which said, suggested that we may go back. I have to have a look at it, but I know my name was in that document. That's just more recent, obviously, with the inquiry.
But in any event, in relation to the procedure as it was in 2003,
yes,
when the investigation began of your complaint, your concern expressed in your statement, as I understand it, is that it was skewed too much in favour of doctors.
Totally. I mean, we were arguing in the dark. They knew everything that we had complained about, and we could see hardly anything at all of their response.
We can take that down. It's not in your statement, Carol, but something you mentioned before you started your evidence today, that in terms of making complaints or asking for matters to be investigated, the body which had been perhaps the most receptive was something I think you called the Office for the Supervision of Solicitors.
It was, yes.
Now, I'm not going to ask you to detail the substance of any of the complaints or what was or wasn't upheld, because that might really be to the margins, if at all within the inquiry's terms of reference. But do you have any observations about what made that process of investigation and regulation, from your perspective, different to the GMC or the police or the other avenues you've sought to explore?
Well, they listened to us and they didn't immediately make judgments. We were able to see a lot more information so we could respond properly. We were treated fairly and with some kindness, that we were, we were, well, a patient, and his wife, and that we hadn't done anything wrong, and that, we deserved to be listened to. And I am grateful that they upheld 3 complaints.
Can I then, moving to a different topic, ask you just a little about the US litigation in which you had some involvement.
Yes.
You've mentioned it in your statement, but for the benefit of those listening, what was that litigation and what was your and Pete's involvement?
What we wanted to do was try and take a case against 4 US pharmaceutical companies. And American campaigners were very helpful and gave us the name of the one that they trusted, because they'd had issues with their representatives in America, as we had had here. So we got the name of a company in San Francisco, Leaf Cabresa, and Pete was the only one that had legal aid, and so the case was for Pete. But we persuaded the solicitor that was representing us here to try and get as many people there as possible. So I think on the back of Pete's case, I think there's about 300 people. I think it was about 300 managed to get there. But unfortunately, the judge ruled, forum non-convenience. But it was very useful because the farmers accepted, they did accept us. If you had a certain amount of evidence that you could prove, you're accepted by the farmers. Now, there was a small token payment, but what was said was really the first line of duty of care was with the authorities here, the government and the authorities here. So it would have to go back to UK courts. But in that process, we were able to trace, Pete's batch numbers back to Arkansas State Penitentiary and even to an infected donor. So I think what had happened was, as prison donors were identified as being infected, they had a look back to see if they'd been plasma donors in the prison. And for one particular batch number, we even know how many prisoners donated. So there was quite a lot of detail that made very strong evidence. And also, I should say, I think I've mentioned this before, but at the time Pete was given particular batch numbers from the prison, at that point the plasma programme was closed down on the grounds of safety. So he should not have received anything. Well, he shouldn't have received from prisons anyway, but he certainly shouldn't have received after it was closed down on the grounds of safety. And that second litigation was sort of known as the dumped treatment, because basically the treatment was given here that wasn't fit for America, and their standards were lower, a lot lower than here. I mean, for example, pool sizes, we found out from a congressional hearing that pool sizes could be up to 400,000 donors. Now, I think here they went up to about 25,000 donors. So, the risk level, and the types of donors. So, and also the way the plasma was collected, because, and sorry if I'm repeating myself, but the prisoners themselves in America, in Arkansas, were administering the paperwork for the plasma program. So if, for example, a prisoner was known to have hepatitis, they falsified a name using an Arkansas telephone directory. So, prisoner Mr. Smith, who had hepatitis, could sell his blood because he now became Mr. Jones. And, and then there were so many safety violations with regard to the fact that the prisoners were doing the admin. And it was, it was just, it turned a blind eye to all this. And one prisoner's job, which comes across on Kelly Duda's documentary, was to resharpen needles using sandpaper for reuse, which is just shocking. So we were getting to learn all these things. And another very important point was the use of gay donors and the delays in preventing gay donors from donating. And this wasn't making a judgment on them, they can live how they want to live, no problem. But obviously this was at a time as AIDS was emerging, and there would be plasma wagons outside the bathhouses in San Francisco because they wanted to get hepatitis-rich blood so that they could study it in gay men. That's fine, you can do that. You can, study people, study hepatitis, look for a vaccine. But then what they then did was put the surplus in the plasma pools. So collecting outside the gay bathhouses, plasma known to be infected, At that time, hepatitis B was seen as an indication that a gay man was likely to also have HIV infection. And then once it collected that plasma in the Tenderloin district of San Francisco, it was used to top up the plasma pools.
You mentioned there, Kelly Dudab, another journalist with whom you've had, I think, significant contact over the years.
I did, with Kelly and from the late 90s, and obviously Kelly made what's now quite a well-known documentary, yes. Factor 8, the Arkansas Prison Plasma Programme.
You've mentioned already the work with the regional newspapers and Llewellyn Holdcroft and the Newsnight documentary. You also worked along with Colette on the Blood Brothers documentary.
We did. I mean, Colette was instrumental in getting that made because of her contact with Holly Lewis of Meridian. I had the background with Pete to, certain things that were happening at Trelaw. So we were able to, we actually gave a lot more evidence on Trelaw, but the then society who didn't want to be involved initially, they then got involved and seemed to persuade Holly not to go down certain routes at Trelaw. One being the experimentation on haemophiliacs at Trelaw, and the other being sexual abuse at Trelaw.
Last topic I wanted to explore with you is just a little more about the volume and scale of documentation that you have considered over the years. Just as a rough estimate, for example, you've provided a significant quantity of material to the inquiry, far more than is represented just by the documents referred to in your statements. Do you have a rough idea of how many documents you've supplied to the inquiry?
I don't. I've lost count, but I would say there's still only a fraction, because one of the things that I said to Kevin, who's very kindly helped me at the inquiry to get a lot of this information together, was that I didn't send anything that we saved, or very little that we saved at the National Archives at Kew, because there was two things. There was, in 2005, Sir Patrick Jenkin and myself worked hard to find out more about what documents were available. And we then managed to get an agreement by government not to destroy any further documents. So basically, anything that's there, blood policy-wise, in NAQ has been saved because we fought to save it and could have been destroyed. So I have a letter from Sir Patrick Jenkin on that. And then there was we saved the documents that went into the self-sufficiency report. We managed to get them freed up and into the public domain. Then we saved documents that were related to the hepatitis non-A, non-B look-back study. So basically, at one point in 2005, we said, please don't, there could be an inquiry in the future. Please give us a guarantee that you will stop destroying any documents, because we were hoping for a public inquiry. So we did get that agreement. And then I discovered all these copies of the HIV litigation documents that were shared during the disclosure process in 1991, and had those returned to NAQ. And this is what people are now able to access through, through freedom of information. But then, to my dismay, I discovered that the Department of Health legal department had destroyed my letters of return. Now, I've kept copies, fortunately, and so if you go to the National Archives Kew, there is nothing whatsoever that indicates all these documents I saved and returned, which I'm furious about. And at the time, I did want to find a neutral place for these documents. And I went to the Haemophilia Society at that particular time and said, would you be prepared to hold these documents? And they said no. So we had no choice for them to go back to the Department of Health, because they'd destroyed their copies of the HIV litigation documents, most of them. They found out that we had found these copies and they wanted to see what we had. Because bearing in mind, obviously, it's many years since the original litigation, so current governments would not necessarily have any idea what were in them because they'd never seen them. So, as I say, these are the documents that the press, they're going into the press now, but unfortunately, a lot of the mainstream press are doing a really bad job because they are saying these documents were newly discovered from 2016 and 17 onwards. And these were the same documents that we presented to ministers 20 years ago that are referred to in letters, referred to in the dissertation. So it's utterly frustrating. And one of the things that I want is I want NAQ to properly reference the return. I mean, I've even written, and my lawyers sent it to NAQ, I've written a page giving it the background history so it can go down for everybody to understand. Because one of the things as well is I get accused of not sharing anything. It's unbelievable. You know, oh, well, you didn't do this, you didn't do that. And I said, I've shared thousands of documents, but it's not recorded. The government's destroyed the return documents. You know, if I hadn't kept them, there'd be no evidence whatsoever I ever sent these documents back.
And we talked about a number of ministers earlier. Someone with whom you shared documents, who then I think made some use of them after leaving office in calls for a public inquiry was Andy Burnham, from whom the inquiry is hearing next week.
Yes. I initially wrote to Andy, and I wrote a letter entitled something like The Broad Street Pump, which is about Jon Snow and his investigative work. I wrote him in 2009, and I was angry with Andy for quite some time because I felt he hadn't listened, and you know there was press articles where other campaigners had camped outside his door and couldn't get a response. And then at some point I sent a message to Andy, and I more or less said, if you don't speak out, I will go back to court, basically, try and establish a case in court. And one point I got a letter from Andy, and he, which I've submitted to the inquiry, and he was basically told from civil servants that there was nothing further to do with haemophiliacs and contaminated blood. So in his eyes, he didn't think there was an issue, even though we kept sending him stuff. But what he did say was that he realised through Paul Goggins, an MP, that clearly it was a very different picture. Now, Mossy had Paul Goggins as his MP, and we would meet with Paul Goggins, Mossy and I, and share our evidence with him, because obviously I was supporting Mossy with his legal case. And I would go to his, barristers with him in Liverpool and try and explain the situation. So I think because of the work we did to educate Paul Goggins, that got passed on to Andy. So of course he went into Parliament, and he used a couple of documents which were from my dissertation, and I think I'd originally sent them in 2009. I think one was the Galbraith, I think he used, and then I think he might, did he use the cheaper than chimps? I think he used the 75, but I think it was two of those documents that he used, I think, when he was trying to make his statement, and said this is, a criminal cover-up on an industrial scale. Yes. Which is what I absolutely believe.
And obviously we'll be able to pick that up with him when he gives evidence a week today. Carol, there's really just one final question I want to ask you. You've been campaigning, writing since 1994, alongside obviously the caring responsibilities for the years between 1994 and Pete's death. And that's dominated your life, I think, since then.
Absolutely, yes.
Because you've been trying to push for an inquiry, for recognition, for financial support. Back in the 1990s, if the infections having happened, but if the government had responded differently, had set up an inquiry, had set up a more comprehensive financial support scheme, what difference would that have made to Pete's life and to your life, do you think?
Well, I think Pete would have had some peace of mind. I mean, Pete was an incredibly forgiving man. Even at the very end, he was forgiving. And I think if somebody just said, look, we made some terrible mistakes and we really are genuinely sorry, and we're going to give you some compensation, it would have meant we would have had some comfort and we could have relaxed and enjoyed our time together, what was left of it. And then after Pete died, I was unable to move on because I'd given a commitment and I wanted to get truth and justice. And for example, I was headhunted to do a PhD. I was offered an opportunity, a funded place, and it was part-time, and I really, really wanted to do it. And I was going to do it, and then I had to look at it seriously, and I thought, how can I do a PhD when I'm working night and day on this? I literally work through the day. My average sleep is two hours a night, 3 if I'm lucky. And this has gone on for years, which is probably why, I'm quite a mess, sort of physically and mentally sort of keeping this going. But I would have probably done a PhD. My health hopefully, would have at that point, there might have been some chance of things improving, and then I could have gone back to work. After some years, I might have even met somebody and been able to go into another relationship. But, I would say, it would have to be a special person who would, sort of take me on with all this crap, So, yeah. So it feels as if a big part of my adult life has gone. The only way I've been able to keep sane, in a way, is one of the other things I do is I use my life experience to campaign in other areas. And because people around the world, they know that I've suffered as well, and that opens doors because they can see that I'm not just somebody who's, distanced from loss and suffering. I've been there. So I'm grateful in a way. At least I can do something, because at least I can use some of that experience elsewhere. And that's been accepted more than here, really. I've mentioned this before. It's no secret, but I'm being, involved in prisoner exchange with regard to Afghanistan and an American soldier, which was worked out very successfully. He's free, and the other 5 people he was exchanged for now running a country in Afghanistan, and it's a very different picture from what's often painted in the newspapers. So I feel as if there's a door there. I can talk to people. I can talk about women in Afghanistan. I can talk about health in Afghanistan, and I want to try and do more there. I want to use my experience to. If I give you an example, can you imagine what it's like to be a haemophiliac in Afghanistan, where the health infrastructure is falling apart, and the assets are currently frozen in Afghanistan. So ordinary people are suffering, and I just want ordinary people to be able to have a better life, not live in poverty, people with disabilities to be taken care of. And I do believe that that's possible, and I know what's going on behind the scenes. And, I want to say to the government, just listen, give people a chance. Things are going to improve there, but, don't punish the population. And another thing I want to say, very strongly is in some countries, they still don't get treatment for haemophilia. Here, people are infected through the treatment. In other countries, they don't have access, still don't have access to treatment. In places like Israel, there's apartheid medical treatment, and I'm in touch with haemophiliacs there. And I just want to say to them, I haven't forgotten you. I spoke to one person a couple of weeks ago, and I will do everything I can to fight for you to have proper treatment. So, you know, I use my experience in ways like that.
Carol, those are the questions I've got, but so if we could have a short break, I'd like to check with Carol's representatives whether there's anything further they would like me to raise. It'll give Carol a short break and then we can come back for a final hearing. I think 10 minutes would be sufficient.
Well, let me just ask, Carol, would 10 minutes be enough?
Yes, that's fine, thank you.
It'll be about that. Council is normally pretty accurate on this. We say not before, not before 4:30. It may be a little later if there are more questions than she anticipates, but after that we'll come back and see what questions the court participants want to put through her to you in the light of what you've been saying.
Thank you. Thanks.
4:30, not before 4:30.